Ladies and gentlemen, we're going to call to order our continued hearing this evening. This is on the application of the Society for Preservation of New England Antiquities, doing business as Historic New England. We had our original hearing on this application on April 16, 2015, and we continued the public hearing to this evening so as to allow the attorneys for both parties to confer with themselves and the neighbors and hopefully come up with certain conditions that they mutually agree upon and to tell us which conditions or modifications of conditions they are presently in disagreement on. So in that interim period of time, we did receive a letter from the applicant, from attorney Alan Lipkind, dated May 12, 2015, with an array of plans and materials attached to it, his suggested modification of proposed conditions and setting forth the conditions that the, I'll call it the Eustace estate for simple purposes, agrees to. We also received a letter dated May 12, 2015, from attorney Dan Hill, representing certain of the neighbors, setting forth his position on the proposed conditions. So we thank both attorney Lipkind and attorney Hill for their contributions to the process. Let me just cover a few preliminaries and we'll start to get into, yes, I have that, I don't need that. My name is John Leonard. I'm chairman of the Board of Appeals. With me tonight to my immediate right is board member Jeffrey Mullen. To my immediate left is board member Stephen Lundbohm. The rules of this hearing are going to be the same as the first. We'll hear from the applicant in any further presentation that they want to make. We'll hear from Mr. Hill on behalf of certain of the neighbors. We'll hear from any member of the public who wants to speak. We're tape recording the proceedings this evening, so would ask that anyone, before they speak, tell us your name and address. Speak up nice and clear and loud. This is a fairly large conference room. The acoustics are not the best, so that we'll know who's speaking, and if we have to revert to our notes or the tape recording of the proceedings, we'll be able to reflect accurately who is making various positions. We did receive in the interim, in addition to the packets from both lawyers with respect to proposed conditions, we did receive a letter from attorney Robert J. Sheffield of Milton, Massachusetts. Mr. Sheffield is trial counsel here for the Eustace estate, and Mr. Sheffield asks that any decision of the Board of Appeals be rendered in the name of the legal name of the applicant, the Society for Preservation of New England Antiquities, DBA Historic New England, so that the record title of the property will be intact. I'm going to construe this letter as a motion to amend the application to formally change the name of the applicant. And I'm not going to read Mr. Sheffield's letter. I think it's brief and to the point. Let me ask my colleagues, do any of you want to be heard on Mr. Sheffield's motion to amend and change the name of the application? Mr. Mullen?
No, thank you.
Mr. Lundbohm?
No, Mr. Chairman.
Mr. Hill, do you want to be heard on this application? Does anybody want to be heard on Mr. Sheffield's motion to amend the application, just to change the formal legal name of the applicant? Since nobody, is there any discussion? All those in favor of granting Mr. Sheffield's motion, say
Yes.
aye.
Yes. Aye.
So we'll allow your motion to amend, Mr. Sheffield, and thank you for your letter. I think that's the appropriate way to handle this particular matter. Let me ask the applicant, Mr. Sheffield, do you want to be heard on where we are in this process? And we're delighted to hear anything else you want to say. What we'd like to do tonight is we'd like to bring this proceeding to an end. But we certainly want to make sure that everyone has the full opportunity to be heard. So Welcome back to the Board of Appeals, Mr. Sheffield.
Thank you, Mr. Chairman.
You want to come up here and have a
Members of
seat
the
or
board.
make yourself comfortable?
I would like to introduce my co-counsel, Alan Lipkin, of Burns and Levinson.
Sure. Welcome to the Board of Appeals, Mr. Lipkin. Good to meet you. Were you here at the last hearing?
No, he was not.
Okay, great. Well, then, welcome to the board. Grab a seat and make yourself comfortable. We're delighted to see you. Oh, whomever wants to speak first is fine with me.
Yes, good evening. I'm Alan Lipkin from Burns and Levinson on behalf of Historic New England. With me today, in addition to Attorney Shetfield, is Diane Vieira, who was at the last hearing, and Ben Harvick was here. He's on the facilities team at Historic New England. I'd just like to briefly tell you a little bit about the project and then really get right into the conditions where Mr. Hill and I, we worked to try to come to an agreement. We did on some, we didn't on others. I'm going to try to focus most of my remarks on the ones we didn't agree to, if that's acceptable.
That's terrific.
If at any time you have any questions, obviously, fire away and I'll do my best.
We're not bashful, Mr. Lipkin, and particularly my colleague, Mr. Mullen.
I got that from watching the last tape, so I'm ready.
How did we look on tape? As terrible as we think we did?
Didn't do you justice. Much better in person, but the tape was good. I've worked with Historic New England for a long time. They're the oldest, largest, most comprehensive regional heritage organization in the country. As you heard last time, they have 36 historic homes that they operate as house museums. What you didn't hear about last time is they also have stewardship programs, which is where most of my work has been with them. In other words, someone has a historic house, they want to put a preservation easement on it, they give a preservation easement to Historic New England, and the perpetuity Historic New England will make sure that historic house is held to be, historically appropriate, and they go to battle over that when need be. But we're here today about a house museum. It's Historic New England's goal to bring history to life while preserving the past for everyone interested in exploring the authentic New England experience from the 17th century through today. It didn't get to be the oldest and largest of what it does here by abusing its neighbors or renting out its historic structures for frat parties. The members of our organization are your neighbors, our board members are your neighbors. They understand the concerns and the fears of the neighbors when there is change, but they're sensitive to that, and the last thing that they are going to do is something that imperils their property, or more importantly, imperils their good name. They have an interest in keeping good relations with the neighbors. I read Mr. Hill's letter. As I said, I work very well with Mr. Hill. We disagree amicably, but to make reference to the size of the endowment that Historic New England has, I think is completely irrelevant to the decisions before this board, which I think is to take into account the uses, and I'm going to address those, see if they have an impact on the neighbors, and if they have an impact that's appropriate to deal with through zoning, put in an appropriate condition. If Historic New England and this structure that's in the middle of an 80-acre site has an indoor function or an Easter egg hunt in the spring, those events, in our view, will have absolutely no impact on neighbors, which this board order condition, whether the endowment is $100 million spread amongst 36 houses, $10 million, $5 million, or a nickel. The focus of the board ought to be on the impact of the anticipated uses on the neighbors. And to some extent, at the last hearing, I watched it on tape. Historic New England started out on its heels a bit because, as Historic New England usually does, before it even got to this board, it met with the neighbors. Mr. Sheffield met with a different attorney who was representing the neighbors back then, and we thought we were close to an agreement or a decent set of conditions that wouldn't need much of the board to resolve issues. I attached to my package not only the assessor's map to give you an idea of where all the parties are and the distances between the parcels, but if you look at tab B to my letter, you'll see that's a plan that this was our initial plan for the property. You see Chestnuts Run going up kind of the left side of the picture, the museum's in the middle. And our parking area was in an area that's, I think it's an orchard that was planted in the 70s. The traffic was going to go up to the right of the gatehouse, then cut left to avoid, you'll see a grouping of trees there, and that grouping of trees is very important, as you'll hear a little bit later in my remarks. That's a grove of very old sugar maples and hemlocks, and we took the traffic up that way because we were taking it off of the lower part of Chestnuts Run. This is the museum traffic. And you take a left there and then a right on Chestnuts Run. And that part of Chestnuts Run, Historic New England owns on both sides of the road. Chestnuts Run goes right through our property. And we were going to put the parking up there in the in what I would call the orchard area. We met with the neighbors. I didn't, but other people did. Mr. Sheffield met with another local attorney. Apparently, they didn't want to see the cars or see the people associated with the cars for whatever reason. We came back to them with this plan that's at tab C, and it's largely the same as the plan that you have in your package, the package of plans. I think it's, if you look at the one that's called site plan. And a lot of work, it may not be apparent to you, went into this site plan to move that parking area over. Now we're cutting a plan through those sugar maples, and trees may not, I don't know what all your feelings are about trees, but the landscape that's associated with this historic structure and the way it was set up by the Eustace family is very important. I stood in the middle of that grove of trees before I came over here, and they are some very, to my eye, I'm no arborist, but there's big, thick sugar maples, and they picked a path through those trees to maintain the outline of the grove, so the change would be as imperceptible as possible, and they're going to have to pick a path through the trees.
You know the width of that path, Mr. Lipkind? Approximately.
I have it in my papers. I don't have it at my fingertips. I can give it to you at the close of the hearing. And you may recall, if you look at the site plan C1.0 that we gave to you, we moved the parking area over. If you look on tab C to my letter, we're putting in a thick vegetative screen at the edge of the parking area. And I don't know if you do have the proposed site plan with you, but I took out another copy just for ease of reference, if I could give it to you, and I highlighted just 3 features on it. Please give one to Mr. Hill.
Do you know how high the plantings are on the edge of the parking lot there?
You mean the ones we're proposing?
Yes, you're proposing to build.
I can look at the landscape. It might be on there.
Mr. Hill, do you have a copy of this?
I do. 32 to 44 inches. They're being spec'd at 32 to 44 inches to start. Height, yeah.
The height to start is 24 to 36 inches. I assume with time they'll grow, but it's all shown on the planting plan at the back of the package. The reason I've given you the highlighted proposed site plan, I think Mr. Hill got a copy. You can see on here that proposed crushed stone drive, and that's the one that's going through the grove that I just mentioned to you. You can see the proposed parking spaces that are there. We got 48 in the crushed stone, and then the overflow, 56 parking spaces. That overflow 56 parking spaces butts right up against a wetland buffer, and I guess the point of this exercise is to show you that it took a lot of work to engineer that.
I'm sorry, can you hold on one second? Hey, gentlemen, could you keep it down? We have a hearing going, and we can't hear a thing with all the chat. Mr. Levin.
Thank you. We did that work to take the parking and the traffic completely off of Chestnut Run, even though Chestnut Run goes through our property and and HNE owns the land. If you look at the assessor's plan that I gave you, at least another 300 or 400 feet on the other side of Chestnut Run. And that took a lot of work to do it. And the reason I'm bringing it up is really to address a request that Mr. Hill had in his conditions, that he had a very broad request. I don't remember what the exact words are. Anything having to do with this be moved 200 feet off Chestnuts Run. We moved that parking area as far as we could. And it's not just a matter of shift things a little bit more. You're going to be running us into
Into the wetlands.
and it's not that easy to fit parking spaces in. This may look from the top down on an aerial view like A and B, like everything's flat and you could just move things around, but the property slopes in a lot of places and we're running up against that wetlands. And I just think that if you go out there, it's tough to even see other houses, at least in the summer when the leaves are out. So like I said, we own the land on both sides of that Chestnuts Run. I think I'm going to move into intensity of use because my memory of watching the last hearing on the tape was that's something you wanted to hear about.
Yes, sir. Could I just ask you one question? On Chestnuts Run, on your Exhibit A that's attached to your letter, you have that indicated in red, do you not?
I thought it was pink, but we'll go with red.
It is pink. You're right, it is pink. And I know you didn't draw this to scale.
This is an assessor's map, and I just took a highlighter and went over it.
Okay. Does it attempt to indicate the rough position of the road, and then you indicate additional land that I'll call it the Eustis Estate owns on the other side of Chestnut Run as well?
Yes.
Which is what you were referring to
Yeah.
when you were talking about Mr. Hill's proposed condition.
Right. In other words, if you're looking at the map, Chestnuts Run is highlighted in pink, and I think he wants a 200-foot area where nothing can happen, starting to the left of it,
Yes.
Okay?
But you actually own large acreage to the left of that.
The left and the right.
And
We
the
own on
right.
both sides, going up to the Jeffries lots. I mean, I got that information off the assessor's website, who owns what's lot, and I tried to get the people that I thought Mr. Hill was representing.
Great, thank you.
Except I don't think he represents Paiz. I'm not sure how to pronounce that, P-A-I-Z, but I figured they were on the road, so I included them.
Great. Why don't you talk about intensity of use?
Thank you. Yes, I think that the last time we were here, Ms. Vieira went into that to some extent, and you questioned her about that, and she gave you a handout. I incorporated a lot of that into my letter. But I think what I'd like to address is there's this concept of a numerical limit on the number of, we both use the phrase special events in our proposed conditions, but we define those differently.
Yes.
And you have to bear in mind when you're talking about special events, I mentioned that one of the missions of Historic New England is to open these historical facilities to the public. And this doesn't mean little old ladies or little old men inside the house looking at the fabric on the wallpaper and seeing, gee, that's historically, that's the way it was back in, whenever this building was built. It means opening up the outside of the property as well, seeing the setting of the building, the landscaping to the public, and that would include kite fairs, other sites that Historic New England has, occasionally brings in an old-time baseball game, Easter egg hunt, things like that. If you look in our letter and Ms. Vieira's handout from the last time, it gives you some of that information of the types of events that we have. If you look at the condition as drafted by the neighbors for events that would be subject to this numerical limit, it's a very broad definition that I think is asking the impossible of your building inspector. An event, here's the definition, an event that is not directly related to the principal use of the property as an architectural museum. Maybe the members of the board could figure that out on the fly, or the Supreme Judicial Court, but I think that's just an invitation to dispute. I think the definition ought to take into account what is going to impact the neighbors. And I don't think indoor events in any way will impact the neighbors, other than they might see people if they walk onto HNE's property up to Chestnuts Hill Run, and take a look over, they might see people. Our parking's going to be behind bushes. It's HNE's position that indoor events ought not be subject to this numerical limitation, nor should outdoor events without sound amplification. Because if that's not the case, you could have an Easter egg hunt one day, then for a whole month you'd be barred from having an outdoor event with amplification. And I don't think that the neighbors, I understand people are concerned about noise. That seems like the principal concern of the neighbors. That's what I'd be concerned about if I was a neighbor. But I don't see how a ban or a numerical limit on indoor events impacts that, nor an outdoor event without sound amplification, especially where you take into account where this building is and where the neighbors are. I just don't see it. In reading Mr. Hill's letter, it's very well written, but when you purchase a lot of land next to 80 acres of developable land, it's not reasonable to expect that you're never going to see or hear someone, especially when your access to your property is directly through the middle of someone else's property. We'd think, and we'd request the board to adopt the condition as we drafted it, that only outdoor rental functions with sound amplification ought to be limited in number, because truly those are the only ones that could have an unreasonable impact on the neighbors. As I said before, I went through the process of Mr. Sheffield meeting with the neighbors. We moved the parking area. We also made a very, very big concession on the number of events, bringing it to 12 per year at a maximum of 2 per month, bearing in mind the seasonal nature of outdoor events. Without speaking to the client, I would guess you probably have 4 months at the most to do outdoor events, like a wedding. You're taking a risk if you don't do one in July or August. It's a big concession. We made it, and to our knowledge, at least, I don't want to misstate what Mr. Sheffield told me, I don't think anyone else in town of similar use has that sort of numerical limit. If, and I understand the neighbors are concerned and you want to do justice by them, but they are not without remedies in addition to what the zoning board might impose. Like everyone else in town or anywhere else in Massachusetts, if a problem arises and there's too much noise, they can call the police or they can call HNE, or they could bring an action for nuisance and get an injunction. It's not an immediate gratification of having a condition in a zoning board decision, but if it's let's say in the off chance there's noise and sometimes things don't go according to plan, what is really going to happen if someone's noisy at midnight? Not that
Call Mr. Sheffield.
They may call Mr. Sheffield. They're not. I don't think they're going to call one of you.
Pull
They're
the
going to
plug.
call. They're going to call the police, or they're going to bring a suit for an injunction. I just think it's your board. I don't know what conditions you usually impose. I sit on the zoning board in my town. We tried to avoid putting conditions in that are more appropriately handled by other regulatory regimes or private agreements between the parties. I just want to say a brief word about the fact that raising funds is essential to the core mission of historic New England. And yeah, if you look at, they have an endowment, yes they do, but if you keep spending your endowment, you end up with nothing. And let's say they make $5 grand on an event and lose it, that's a lot of money. Each of these properties they have to look at separately. When you're out there fundraising in the charity world, there's not really much, no such thing anymore as unrestricted funds. Everything's related to a purpose, and they're going to compare this property to others, and it's got to do as well as it can to running on its own. If I could, I'd like to move off of this idea of what events ought to be regulated in the number. As I said, we think it's only outdoor events with amplification, 12 a year, 2 per month. I'd like to speak about proposed limitation on the term. I watched the tape the last time. You did express a desire to have, I think you called it a look-back period. Something like, I don't remember who said it. I watched the tape a couple of times. And to us, I'm advised that there's a standard condition that the board adopts that says that things can be amended at any time in substance, not those words. And when you add that to the fact that someone can go get an injunction, We don't think there should be any term limit, or I wouldn't think so, but I drafted one, and I picked a 5-year term for a few reasons. I thought that there's precedent for it in your zoning bylaw. I think it's the wireless
Telecommunications.
Telecommunications,
telecommunications for
yes.
5 hours. I tried to use the methodology in that case I gave you where it's automatically renewing unless someone objects, and then there's a...
Pardon.
Right. I forgot the name. That's the methodology that I tried to go with. Having a 2-year period, especially running from the time the permit becomes final, this property is not going to open for another year. So when you get to a point, once we open, we'll have basically a 6-month period of operations, and we're going to have to tell people we can't book your functions anymore because we may lose our permit in 6 months. This is a property where the client, I think you heard last time, the client paid $7.2 million for the property. They're spending another $4 million on top of that to tie into the public water, to fix the failed septic, for accessibility repairs, new driveway. I showed you the plans for cutting the path through the trees. So I think that the 5-year period is much more appropriate if you're going to impact any period. As I said before, we're not going to operate at all for a year, and I don't think you're going to get a good picture on how in demand this property is going to be. I'm informed by Ms. Vieira that when they open these things up along the other 36 properties, there's kind of a novelty effect. People in the organization, oh, we just got this property, let's have an affair there. After that, it kind of dies down, and the neighbors remain protected by nuisance law. And if I could, I'd like to move on to noise.
Fine.
Again, you weren't bashful last time. You already got the facts of the case, so I'm just trying to focus on the conditions
I appreciate
where
that.
Mr. Hill and I didn't see exactly eye to eye. Noise, I think, is a legitimate concern in theory, but if you go out there and take a look, or if you even look at the assessor's map, there are great distances out there. I'm informed, having gone out there, if you go out there, the back of the property, as you head back to the Shallingford lot, there is a farm operation back there run by Brookwood Farm. The farming equipment runs, I don't know how often, that seems to make noise. It doesn't seem to bother anybody. Mr. Hill suggested that this board adopt a DEP regulation. I think the DEP regulation, if it applies, it's there, and as stated in the regulation, it's to be applied by the Board of Health. It doesn't need to be part of a building permit decision.
Can also be enforced by the police department, fire department, or building inspector
Right, that's all stated in the...
without it being in any decision.
And I think that's a more direct route than let's go dig out the special permit when someone's making noise when it's too late or it's too loud, things of that sort. So I think it's more appropriate, if you're going to adopt a noise standard, all I put in our proposed conditions, that the noise not be unreasonably loud, and that's, if they want to seek relief at the zoning board, I guess, maybe the zoning board, if it wants to entertain that sort of dispute, that's fine. Now, they also have a condition that directing amplified sound 180 degrees from Chestnut's Run. I don't think that the board ought to impose any condition directing which way speakers ought to be facing. I take it in looking at Exhibit A to our plan, to my letter, which is the assessor's map, 180 degrees be pointing towards, I think it's lot number 2. Can you make out lot number 2? It's kind of fuzzy, but it's towards the left of the page. That's where they would want the speakers pointed. We think, in taking into account where the trees are and the topography, that's not the way, that's not the way.
Go ahead, I'm sorry.
Yeah, we think a tent would be located just behind and to the left of the house, and the speakers would be facing towards Canton Avenue. And it's a little bit deceiving on this map, but I was out there today. It would really be pointing towards the gatehouse. That's the way the property and the trees and the tent would line up. It's a very far distance to anyone. It's not heading towards Butler. And again, as with the neighbors are protected by the noise regulation if it applies, and also by general nuisance law, and they're also protected by the decades, for what, I know it's not something you could take to the bank, but it's as close as you can. That decades of operating these things that Historic New England has run these things for, and if an issue ever occurs, they deal with it. That's how they got to be where they are. Now I'd like to address, if I could move on from noise, the proposed condition that says all outdoor activities and components of special events have to be 200 feet from Chestnut Run. I'm not sure what that means. I imagine it means that they want us to move our parking area even further. But, you know, if we're having a wedding and the parents of the bride or groom want to take and walk in the orchard, I mean, we own the land for another football field on the other side of Chestnut Run. No one's even going to see them unless they're driving through our land, as they have the right to do. I think it's not reasonable. I think it's overkill. If we're having a kite fair and the kite flies over the apple orchard, is that, I'm not sure what it means. I think it ought to be eliminated. I think of it as a solution without a problem, and moving the parking areas, really, it's going to be very difficult to deal with that. With that, I think most of the other conditions, I think Mr. Hill and I agreed on. It really comes down to, I think, the noise and what's a special event and how many of them. So I don't want to take up your time unnecessarily. I know you're pretty busy, so if you have any questions, I'd be happy to answer them.
Great, thank you very much. Mr. Mullen, do you have any questions of Mr. Lipkin?
So when you say that the DEP noise ordinance, if it applies, can you expand on that sentence, what you meant by that?
Sure. I'm not a noise expert by any means. I do some permitting work. I've seen it applied in cases. I work with a concrete manufacturing company. They come out and they test the ambient noise, they test the equipment you want to put in there, and they measure the difference. Here, if you look at these regulations, it talks about, if you look at the definition, in order for noise to be regulated, it has to have an unreasonable interference or impact on somebody in order for it to be considered noise pollution. That's how I read this stuff, and I don't know whether anything we'd be doing here would be subject to it. There's another provision in there that says that it does apply to public gatherings and things like that unless they're permitted. Now, I'm not that familiar with your liquor laws here in Milton, but I know there are some circumstances. Mr. Sheffield explained it to me. I've got to confess, it didn't all sink in. I was trying to get the rest of the picture. There are some circumstances where someone has to go get a permit from, I think, the Board of Selectmen if you want a liquor license.
Daily
One-day
permit.
permit.
One-day permit, yes.
Yeah,
That's
so-
my understanding as well.
I'm not sure if you get that permit, does this still apply? I don't know the answer to that, and I just didn't dig that deep, and I apologize for that. I'd be happy to look into it and give you a supplemental filing, but
I
it
don't
probably applies. I'm just not that sure about how the liquor permitting works here.
I would say that I've been to many Board of Appeals hearings in the summer nights when there's a band playing outside the town hall, and it surely it exceeds those standards. But you know, it's music, and most of the time, unless it keeps you from hearing what's going on, it sounds fun.
Mr. Mullen, do you have any further questions? Mr. Lundbaum?
Yes, I had a question. Looking at tab B, I think we see I think what purports to be the,
I'm sorry, I missed the last thing you said, sir.
on your tab B,
Yes,
I think we see what purports to be the event tent, that white.
yes.
Okay, I don't see it on C, but is it fair to say you did have to move the parking?
Yeah,
But
that tent was originally supposed to be, I believe, on a pad, and I don't think that's the case anymore. It's going to move more, my understanding is going to move more
The-
down and to the left a little
The
bit.
original plan was we would construct a pad, we would be putting up a tent, say, in April, and removing the tent in September or October. We've done away with that now, and anytime there would be a tent, it would be a one-day tent like at Milton Academy, or that they use for Curry College graduation, et cetera. So there'll be no tent pad there, there'll be no tent during the summer on a regular basis.
When the tent is utilized, Mr. Sheffield, where would it be located?
It would be
On
lo-
Exhibit B?
It
or
would be
Exhibit C?
located behind the house. If you look at that tab B, it would be located to the right rear of the house.
I just sketched it out rough, would you like to see?
I would, yes, please.
I just showed it to Mr. Hill, obviously this isn't the scale.
Yes,
It's the
sir.
short end here, then
Yep.
the speakers would be this way. facing
Speakers heading this
the
way.
gatehouse.
Yes.
Speaker heading down. You know, with respect to these event tents, has anybody, and I haven't been to a lot of events in these tents, but has anybody given consideration to the type of tent used? I know that they have these tents that can be fairly well involved, and they have drop-down walls and windows and doorways, as opposed to just a roof structure where it's wide open, and you could imagine that noise would be different in that type of tent than opposed to one of these sort of closed-down
Do
structures
you wanna
that I've seen.
I can. Typically, the tent rentals that we use for functions have the sides. It's very rare that it's simply a canopy.
Okay.
It's the tents with the sides. And we can make that a requirement.
Okay. Attorney Lipkin, you were addressing the 200-foot setback issue, and I heard you on that. Did you have any comment on the next part of the sentence there, of Attorney Hill's condition with regard to guests and event staff not using Chestnut Run for access to any of these events?
We all agree
We're okay with
that Chestnut Run will not be used for
Access.
access to people coming to the events at the museum.
Just to be clear, however, our H&E staff, and I don't know if any of you have been out there, there's a building out there that they use for equipment to maintain the grounds, that they need Chestnuts Run to utilize that, but that wouldn't be associated with these special events. And I believe that Brookwood Farm also uses that and has used that for some time. But I don't think that's an issue with anybody.
That's all I have, Mr. Chairman.
Okay, I have no questions
I
of
have
Mr.
another
Lipkin.
question.
Mr.
Go
Mullin,
back to
please.
this DEP issue. So, I want to talk about the guideline. Your letter says that the DEP regulation sets out a standard that's essentially a nuisance standard. And you say that there's no need to add the Board of Appeals to the mix of government agencies. But isn't another way to look at it simply agreeing that the noise guidelines apply? And that the Board of Appeals aren't seeking to enforce the noise guidelines, they're seeking to enforce their special permittee to comply with the noise guidelines. You see the difference?
I don't see the agreement in substance, because if it's put in a condition in a permit that H&E shall is bound, H&E shall comply with that. If they violate that regulation, you not only have a violation of the regulation and a violation of common law nuisance rights, you now have a violation of your special permit. So it's, I don't know, I don't want to call it piling on, but it's really a third remedy, and it's just the practical way to deal with it, I would think, would be either with, I would think the health department deals with noise, that's who does in my town, or a private action for nuisance, not to come back to the zoning board and have it out here. But, that's my viewpoint. You'll decide. I think it's, the remedy is already there. You don't need another forum for it.
And it's clear in the CMR, and I'm referring to 310 CMR 7.00, if 7.52, it says that any police department, fire department, board of health official, or building inspector or his designee acting within the jurisdictional area may enforce the Department of Environmental Protection's noise regulation.
If it applies.
Pardon me?
If it applies.
I proposed a condition. I mean, I don't want a noise condition that basically says thou shalt not be unreasonably loud. I mean, I understand what that means. And we
What's
can
the
agree with that.
citation, Mr. Sheffield, that talks about the,
310 CMR 7.52. And in reviewing the Wallaston Golf Course permit, there is a prohibition of unreasonable noise without defining it more specifically.
Mr. Mullen, do you have any more questions?
Not right now.
Mr. Sheffield, do you have anything you want to add?
No, thank you.
Okay. So I don't have any further questions. Mr. Hill, do you want to be heard?
Sure.
If you want, gentlemen, you can stay right there, and Mr. Hill can move over here, and you'll have all your materials at hand.
Mr. Chairman, thank you for the opportunity to be heard, members of the board. I guess just starting from the beginning of my letter, first the premise, we recognize there's distinctions between events that are related to the museum and events that are not. And what I tried to do was carve that distinction. I tried to make that clear in our condition that we aren't seeking to ask the board to regulate museum-related events. And there's a whole body of case law that governs that. There's land court cases, appeals court cases that talk about what's related to a Dover Amendment use. This isn't Dover Amendment, but the analogy is perfect. If it's related to the museum use, we're not going to, we don't have any right to challenge it. The board doesn't have a right to regulate it. If it's not related to the museum, it's a commercial activity, and it would not be allowed under zoning. So there's a distinction. There's plenty of case law that would guide anybody on this. And I really want to emphasize that I think we're kind of looking at this too literally. We're not, there may not ever be a problem. Mr. Lipkin stated, this organization has been in existence for 100 years. We've never been bad neighbors. We have a track record. Trust us. We want to trust them. And if there's not a problem, there's not going to be neighbors coming knocking on your door to seeking to enforce the special permit or seeking to enforce the noise regulation. But I think it's reasonable just to put some parameters in here. And if it's related to the museum, we're not interested in regulating it or having the board regulate it. If it isn't related to the museum, we think it should be regulated by a set number of events. So we thought that 12 events per year was reasonable. I don't think we're that far apart. But we also think that that should include the indoor events. And Mr. Lipkin says, well, that indoor events won't have an impact. I beg to differ. And I think we have to look at first the setting here. This is a very unique setting. This is an estate where there's not a lot of trees. There's a lot of wide open spaces, and noise travels when there's nothing to block it. The member asked about the sides of tents. My acoustical consultant, who we consulted with on this, said the canvas sides don't actually make any difference at all. Sound goes right through them. Sound will travel unless it's really blocked by something that's solid. So in this case, we've got a lot of neighbors, and yes, they are far apart distance-wise from this estate, but sound travels when there's nothing to block it. So we are concerned not just with outdoor events, but indoor events, because at indoor events, the museum can accommodate, I believe it was set up to 99 people. That could easily be a wedding, some other celebration or function. People will be congregating outside on a warm summer night. I don't think it's unreasonable to say the 12 non-museum related events have to be capped at 12 per year, 1 per month. With respect to the term, we actually, I frankly don't think the nuisance remedy is all that viable. I have a lot of experience representing abutters and neighbors. That's really my practice areas. I represent abutters to projects. I've been doing it for 15 years. And I very rarely see a situation where an abutter could bring an enforcement action under a nuisance theory or some other theory, and a judge would look at the special permit. The judge would say, gee, there's a special permit that allows this. I'm not going to step into this. So I think this is really the first line of defense for us, that it's important for us to have reasonable conditions that we can say, gee, you didn't comply with this. We're going to go to the zoning board or first to the building inspector and say, you know what, we think there was a problem here last weekend. We'd like the building inspector to issue a letter to the proponent, to the museum, saying, yeah, there was a problem, don't repeat it. And hopefully that goes away. But I think that's the appropriate remedy for these kind of situations. We also think 2 years is an appropriate period of time. 5 years is a long time for us to wait to have a look back. I also don't like this open-endedness of anybody can come back at any time to modify the conditions. That leaves a lot of uncertainty for us, that we always have to be kind of looking over our shoulder saying, is the museum going to ask for a weakening of these conditions, for example? So we think a 2-year period with certainty is good for everybody. It's good for them because they know they have that they can do these events for 2 years, and we have the certainty of knowing that if there's a problem, we can come back. So I think 5 years is just too far. With respect to the noise, we thought that a 200-foot setback is appropriate. Again, it really has to do with the setting. You may think 200 feet, gee, that's a very long distance. It is. But given this setting, I think it's appropriate. I don't think, looking at their site plan with 80 acres, I don't think that it's asking a lot to modify the parking somewhat by just pushing it further towards the Quinn Estate. We think the events, and again, I hear the concern about, well, what if a kite flies over the orchard, or what if the wedding party wants to have a picture taken that's within 200 feet? Look, no one's going to complain about that. What we're talking about here is the actual event. We're talking about the tent, the band, the parking, that kind of thing. So we're going to be reasonable just as they're going to be reasonable. We're not going to have a police, we're not going to have citizen policemen standing outside on guard watching to see if they trip over the 200-foot line. But I think there should be a line.
Could I ask you a question here? Because I may be wrong, and Mr. Sheffield would certainly know better than I would. But if there was to be a wedding at the estate with 100 people or 150 people, does the municipality require police officers to be present, particularly if alcohol was going to be served?
Oftentimes, the selectmen will require it as part of the one-day liquor license.
And does that depend on the size of the wedding or the location of the wedding?
It depends on the size of the wedding, and also it depends on the type of street it is. Usually the police chief, and we've met with the police chief. The police chief makes a determination of whether a detail is required or not. If he tells the selectman that a detail should be required, then the detail is just made a condition of the one-day permit.
Okay, so if
Never been an issue, never been a problem that I know of.
then perhaps the police chief would exercise his discretion early in the permitting process here to have a policeman present.
He may in the beginning or
So you don't
on the
have to
side
call the
of
police. The
conservative.
police are
Yeah.
already there
Yeah.
to make sure that things are in hand. I'm sorry, I didn't mean to interrupt, but that question occurred to me.
Sure. So going back to noise, we actually think it's a smart thing to do to reference the state noise standard. we're sitting at a table full of lawyers. You probably all got your Mass Lawyers Weekly news alert today that says that Governor Baker wants to put a sunset provision in all regulations that affect development. So, this noise regulation.
I think that's a little strong.
Well, your objection is noted, Mr. Mullen.
I read it, oh.
But I think there's a lot of criticism of the executive order that
I agree with that.
actually all sides agree that it's really poorly worded. But my point is that this regulation could be gone in a year. It could be amended. More importantly, we shouldn't have to go to DEP, which would be the ultimate arbiter of this issue, to enforce this. And Mr. Lipkin says, I like the term prohibit unreasonableness. What's unreasonable? I mean, I think that's a lot more vague. And I think having some sort of standard that we can all live with, that you can't increase noise by more than 10 decibels at the property line, above ambient. And I think if we say in the decision, this shall apply, then that's the rule.
You're really comfortable having the Milton Board of Appeals analyze and interpret this particular bylaw?
If that were ever to happen, first of all, it's unlikely. But if it were ever to happen and on a regular basis, these events are too loud every weekend, we're going to go out and bring our acoustical consultant to the site with a sound monitor and measure it. And then he'll come here and explain to you, here's the readings. So it's not something where you're going to be sitting in a position, what's more than that, what's not. You're going to have that feedback. But I think that's just a reasonable standard, and I don't see any problem with including it. I also don't see a problem with asking the museum to steer the speakers, the amplification, away from Chestnut's Run. It would be helpful, frankly, to have a plan that plots where this tent's going to be. I know you just sketched it, but I think it would be, for the record, I think it would be useful to have a plan that shows it more precisely.
But if you were directing sound towards the, I'll call it the gatehouse,
Yeah.
wouldn't that be of some protection for the neighbors?
Better. It's 90 degrees. I'd rather have 180. I mean, frankly, they own the Quinn estate, so their direct abutter is them. So I think it's better for the neighbors to have the sound going that way. And I mean, just looking at the topographical plan, I don't see a reason why they couldn't just face everything in that direction. It seems like where they're proposing to put the tent is relatively flat, so the way they orient it, I don't think makes a difference to them. I don't see how it would. But maybe it does, and maybe they'll explain that to me. But so we think that's reasonable. And frankly, when I talked to my acoustical consultant, it's actually Kavanaugh Tachi. I don't know if you're familiar with that firm. It's one of the 4 or 5 firms in the state that do this work on a regular basis. They told me that is by far the most effective mitigation of sound, is the orientation of the speakers. And they're actually working on a similar project up in Andover right now, where a farm is seeking to have events. And that's their main mitigation, is to steer the speakers away from the neighbors. And that reminds me, I kind of want to just give a little background of where we're coming from with this, because some people might think, gee, why are we making such a big deal about events? There is a concern, and it's not at all Historic New England's track record. We don't even know if they do these kind of events, but the point is that a lot of these kind of estates become convenient locations to have special events. And I've worked on a few cases around the state. In Natick, for example, Lookout Farm, they started having these winter festivals and October festivals and so forth to make the farm more economically viable.
Is that a profit-making venture? I think Lookout Farm is not charitable.
It's a farm. It's a Dover Amendment. Yes, it's certainly not making a lot of money, but it is a for-profit.
It's a working farm.
Yes. But what they did is they built a train track, and it just became an amusement park, essentially, on a lower scale. We don't expect that to happen here, but it is a slippery slope. And so that's why we're here today, to say, look, we want some reasonable conditions so that there's no temptation to start having festivals and fairs and other things that could get out of hand in the future. Because we don't want to be fighting them. We don't want to have to go to court. And this is really the best way to do it. Get the conditions in here now. Everyone can agree to them, and we have some expectations of what's permissible and what's not. So we talked about noise, and I think that's really those are really the main areas of disagreement. We had the noise issue, the term, two versus 5 years, the number of events. We would like to see 12 per year, 1 per month. And we don't have, we're not seeking to limit their related functions. So if they have a fundraiser for them, that's not within our definition of special events.
But if you're having your special events, weddings in particular, you have a limited season for weddings, don't you? So if you say you can only have one event a month, that would mean that the applicant could only have 4 or 5, presumably, weddings there. Whereas I think the applicant is saying we should be able to have 12 events, but you could have up to 2 a month, so you could concentrate them in the better weather. So.
I realize 1 versus 2 doesn't seem to be that big of a difference, but it really depends on how it turns out. If these weddings in the summer turn out to be, loud and an annoyance to my clients, then it is a problem.
Sure, then we deal with it.
2
But
versus 1 is a problem. Yeah.
On the other hand, as Mr. Lipkind has indicated, that the weddings may be an important factor in keeping this particular segment of H&E financially viable.
Yeah.
In fact, you probably saw the article in the Boston Globe talking about the zoos on the North Shore this morning. It was a front page article that they're not able to raise sufficient monies from admission fees, and they were looking to have events and looking to have fundraisers and have benefactors boost their ability to maintain their infrastructure. So I guess even though this particular H&E may have 36 or 37 particular buildings and areas where they're protecting and preserving, if they look at them all on an individual basis to see if they're self-sustaining, that may be a factor here.
Yeah, and we can understand that. I think it's appropriate to have some weddings. From what I understand, they're only going to be allowing their own members to use these facilities for these events. So that should, so it's not like I could go up to them and say, can I have my wedding there? So that's.
Is that true, Mr. Lipkind? I didn't understand that to be true.
I would say that Diane could speak to that, but it's not written in stone. But what we were considering was only making it available to I don't know how many charities you're involved in, but there are members, and then I'm sure it's more than me. There are members, and then there are members, and this would be for the
Top tier.
higher level of membership. I don't know how they.
So I can't send in my $100 and then have
Exactly
my daughter
right,
married
right,
there
yeah.
next year.
Right.
Okay, so it's for the principal benefactors of the...
I don't know what the words are they used to describe it, so I don't want to throw any out there, but there are different categories of membership, and this would be for the higher ones. I don't know what the lowest level membership is. Maybe it's $25 or $50. That doesn't give you the right to have the wedding at,
Otherwise, the membership is going to go through the roof.
right.
This
That's
is a
not-
very attractive site.
It
Right,
is.
right. So that's what Mr. Hill is referring to. He did
Okay.
discuss that. He's absolutely right. I don't know that it's cast in stone as to which level of membership it would be. We don't want to make it so, you get all these people paying $25 so they could have their wedding, or $50. I don't know what the minimum.
Okay, but the intent is the higher level of benefactors
Correct.
of H&E would be eligible to have
That's right.
weddings there.
Yes, it's,
That-
what we had offered during the negotiation was our Appleton Circle membership, which starts at $2,500 a year.
Yeah, but we didn't,
It's our highest level.
we didn't,
Still a steal.
we didn't want that cut in stone, we want some flexibility on that, but the thought was that it would be for the premium levels of membership. We don't, 10 years from now, there might not be an Appleton Circle, there may be some other
Or it's
circle.
equivalent, whatever the equivalent is. Do
Yeah.
do you think, Mr. Lipkin, that if you limited, particularly weddings we're talking about here, and not other events that you may have outside of the principal building, and they were limited to the Appleton Circle folks, that you'd have less likelihood of a violation of unreasonably loud noises, and you'd have a more
That's-
stable group of people at the
That's a
wedding.
very dangerous path to go. I've
It
seen
is
people
indeed.
with a lot of money make fools of themselves, and I've seen people with no money make fools of themselves, so.
Well, and-
That may be true, but I don't know.
Well, you may have
I
more,
can't agree to
you
that
may
one.
have more control over them, let's put it like that, but I don't, maybe you don't. I
But it
still,
would certainly limit the people who would be eligible to do it. I wouldn't want to handcuff them to say it's just X category of membership. I'd rather say it's just the premium categories of membership, just so they have some flexibility.
I'm not sure if the governor of the Commonwealth wanted to have his daughter married there or something along that line. A special consideration might be given.
I don't think so.
Well,
That's definitely a violation of the ethics law.
well,
2,500.
aren't Governor Patrick's daughters married? I know one is married. Is one still single?
I think they're both married now.
Mr. Hill, I'm sorry. Do you have any?
Just
anything
one
else
last
you wanna
point.
raise?
On Attorney Lipkin's proposed condition list, one of our concerns was just the definition of special events, and I think that's a major point of contention between us. You know, his definition would say that special events are those that are events that are where the uses property is rented by Historic New England to third parties. So again,
And that's not, and there's sound amplification.
Yes.
right.
That's the
Exactly.
case.
So there are limitations there that I don't think are appropriate. I think special events should be broader to include any non-museum related function. So number one, it shouldn't necessarily be a sound amplification. That's obviously a major concern of ours, but that isn't the only source of noise. Rented, Historic New England might,
Well, but if there's no sound, I don't want to be difficult with you, but if there's no sound amplification involved, wouldn't is it the Woodbrook, the Brookwood farm that's operating back there? They'd cause more noise than any of the kids running around or flying kites or doing activities that may not strictly be museum directly related, but wouldn't that be true?
But they've been there. I mean, they're an existing use.
Well, some people would say this building has been there for a long time as
Yes,
well.
but not as events. That's the difference. It's been a private estate.
Well, but isn't one of the difficulties you run here is making rather subtle distinctions as to what benefits the neighbors, what's the type of protection they need, vis-a-vis unduly restricting the applicant and finding out the applicant says this isn't viable, it's too much of a pain in the neck, and selling the property, and you find 100 houses going onto the hillside up there. Isn't that the balance?
I think you're right. I think we definitely prefer the museum over a subdivision. But I don't think that our conditions are the kind that are going to force Historic New England to say, gee, this is too much, we're going to sell this. I mean, I don't think they were counting on hosting special events, and this is just sort of a frosting on the cake. If they can make some money by doing some weddings over the course of the year, then that's great. I mean, that's why I put the information in my letter about their financial condition. I think it is relevant. So I'm not concerned that our conditions are that onerous. And I also think that, it's problematic to say these events are only the ones that are rented, because Historic New England might allow somebody to have the use of the property for free, which it could be an event that's hosted by a different nonprofit that has a fundraiser. I mean,
It could be the trustees of the public library, or it could be
Yeah,
the
exactly.
students from the high school.
and also the word third party. I mean, if they're leasing the property to one of their members, is a member a third party? I don't think we should get into those kind of limitations. I think it's much more cleaner to say, if it's a non-museum related event, it's a special event, 12 per year.
Okay. Do you have anything else you'd like to add?
No, sir.
Okay. Mr. Lipkin, do you want to respond to that, or should we see if any member of the public wants to?
Just briefly, the 200-foot.
Oh, I'm sorry, Mr. Mullen has a question, excuse me. Mr. Mullen.
We didn't talk about distinction between events based on the number of people that are there. Isn't that important? And doesn't that matter in terms of this distinction between special events, amplification, et cetera? We're really only talking about special events at which you're going to have a large gathering. Is that not the case?
I think that's implied. We didn't put.
It's implied?
Implied, yes.
Well, it may make a large difference, right? Because there could be a lot of events that are really no mind, especially if you're not drawing a distinction between indoor and outdoor events. So is there a number of people that we can begin to talk about? I didn't come up in either of the presentations, and I don't, perhaps that's not a fair point, but,
When we were discussing this with the prior attorney, we suggested that there be a prohibition against events having more than 200 people, so that you couldn't have a wedding with, 250 people, regardless. We have an inside limitation of 99 for occupancy standards. And I would imagine that most of the events would be 150 or fewer.
If you look at the special, that the conditions that both Mr. Hill and I drafted, I'm looking at mine. It says special events. Again, we define special events differently. But mine says such events shall not be open to the general public by invitation only and shall